Así es.
Ok. Yo creo que podemos ir comenzando como para ir con el tiempo. Is people connected online already? Okay. So good morning to everyone. My name is Gustavo Guarin. I'm a professor in this house. I'm truly grateful to be here with you today. It's an honor for me to serve as a moderator with this thought-provoking panel on the discussions on the challenges of multilateralism, managing trade, regulatory influence, and environmental justice. I would like to extend my heartfelt thanks to the Society of International Economic Law, Universidad Externado, and Universidad Rosario for organizing this event, as well as our distinguished panelists today, and of course to all of you, the audience online and present in this room. Your participation will enrich our conversation. So we are thrilled to have two fantastic panelists joining us today. Sara Dangon, a lecturer of international law in Universidad Los Andes and Universidad Javeriana, and an LLM candidate in Harvard University, and Juan Manuel Amaya, a professor and director of the International Law Department at Universidad de Los Andes. They will provide a clear and insightful presentation on the topics on trade and environment. Further, I will present my paper, the paper that Colombia submitted to the WTO, the principles and parameters that should guide and support policies and measures on trade and environment. Then I will wear the two hats to this talk as a moderator, as a presenter, and at the same time as the Colombian trade representative on trade and environment before the WTO in Geneva. So let's there. Just help me there, please. Next slide. So the world is changing. In recent years, the international community has faced significant challenges: the pandemic, the war, the trade tensions, socioeconomic inequalities, environmental degradation. The developing world is calling for environmental justice. And that's this panel about: what is environmental justice and what developing countries such as Colombia in this setting is calling for environmental justice. So governments have increasingly resorted to unilateral trade measures to protect their domestic sectors, foreign policy objectives, uphold environmental values and narratives. However, these measures often worsen economic problems and reinforce existing imbalances. Today, our panel will delve into these pressing issues with specific focus on the developing world and actions on influential participants like the European Union, and exerting economic and political pressure to control others. By analyzing these crucial aspects, we aim to foster an understanding on the interplay between these power balances or dynamics, right? Globalization and what we mean by environmental justice. So one little remark on policy context. With the urgent need to tackle the environment and climate crisis, a range of trade-related environmental measures, as we call it in the paper, the Colombian paper presented to the WTO, are being implemented and considered. So there are different approaches generating international tensions, which, if not managed properly, may affect environmental efforts to protect the environment, marginalize vulnerable economies unable to comply with requirements, and affect the function of the multilateral trade system. So this has resulted to a need for greater calls for international cooperation on trade to ensure that such measures are WTO compatible and development friendly while maintaining the level of environmental protection. And also a meaningful discussion and debate on the roots of principles relevant to trade-related environmental measures and what it means for the international arena. So next, please. A quick note, I know that you know more or less this issue, but a quick note on the scope of what we have in mind when we talk about environmental trade-related measures. So there are many specific examples of measures that we could mention. So here, I will stand up. So here, there are a broad map of, it's because the microphone, a broad map of what is our understanding of environmental trade-related measures. So we have border measures, tariffs, licenses, quantitative restrictions on imports that target mostly imported goods and services, regulatory measures, standards, label requirements, regulations, conformity assessments that target mostly goods and services on domestic markets, and economic incentives like internal taxes, subsidies, non-monetary support, and intellectual property rights. Those measures can discourage or encourage production. So for instance, in the case of border measures, market correcting measures on imports like border carbon adjustment, right, that the Green Deal, the European Union is trying to implement, discourage the production and trade that contribute to environment. Also, other border measures can encourage production like trade preferences and market access, concessions, removing tariffs and non-tariff measures, etc. So these are what we understand by trade-related environmental measures, and this is the focus of what the interaction between trade and environment should take into consideration. So those are, in general terms, what we are talking about when we refer to this type of measures. So if you can pass to the other. So with this, without further ado, I think let me introduce to my esteemed panelists who will shed light on these important topics. Sarah will discuss the interaction between trade and environment, focusing on factors and elements that influence regulations and environmental justice. She will explore the challenges of harmonizing local regulations, the impact of stringent environmental regulations on developing countries, and the use of unilateral trade measures. So, Sarah, in general terms, what is the main challenge to the intersection between trade and environmental regulation, and how WTO members responded to these challenges, and which is the way forward?
Thank you, Gustavo, for the introduction. I'm honored to be here with Juan, Gustavo. Well, in theory, the intersection between trade and the environment, and between both regimes, should not pose any challenges. International agreements using constructive ambiguity have intended to harmonize this relationship as a pacific one. As for WTO law, you can see in the preamble to the WTO agreement, the preamble contains references to both environmental protection and sustainable development. Also, in the 1996 Marrakesh Decision on Trade and Environment, it reads, there should not be, nor need be, any policy contradiction between upholding and safeguarding an open, non-discriminatory, and equitable multilateral trading system on the one hand, and acting for the protection of the environment on the other. As for environmental law, Principle 12 to the 1992 Rio Declaration reads as follows. States should cooperate to promote a supportive, open international economic system in all countries to better address the problems of environmental degradation. So in theory, trade and environment should not pose, both regimes should not be in contradiction. But this is wishful thinking. In practice, we are confronted with a fundamental issue. This is that although trade requires harmonization, harmonization of local regulations is impossible, is virtually impossible for environmental matters. I will refer first to the trade perspective on the importance of harmonization, and second to why is this harmonization virtually impossible for environmental matters. So, as for the trade perspective, states' harmonization of local regulations is crucial to a fair and free trade. First, consistent local regulations promote market access and alleviate the costs of entering a market for importers. Second, harmonized regulations increase consumer confidence because they establish common benchmarks on safety, protection of health, but most notably, uniform regulations, local regulations, reduce the risk of regulatory arbitrage. And what's regulatory arbitrage? Globalization has pushed down the costs of moving goods and services through frontiers and borders. So as the costs drop down, firms have leveraged differences in local regulations to gain market advantages. So firms reduce costs and enhance their competitive opportunities by relocating in jurisdictions with lower or more flexible environmental standards. This is regulatory arbitrage. Regulatory arbitrage not only distorts trade and investment, but also, and more importantly, labor force and employment opportunities. So, in theory, fair trade requires unified local environmental regulations. That's the theory. And you can see that harmonization of local regulations is at the core of WTO law. You can see this in the Agreement on Sanitary and Phytosanitary Measures, the Agreement on Technical Barriers to Trade, the Agreement on Trade-related aspects of intellectual property rights, the TRIPS Agreement. So harmonization is crucial to a fair trade. But now, why is harmonization virtually impossible for environmental matters? This is impossible for three main reasons. First, because the climate crisis impacts all states differently. So we have small island states that are mainly affected by rising sea levels. Then you have United States, Australia, India that are struggling with extreme weather events. But then you have that China and Africa are struggling with a decline in agricultural yields due to climate change effects. So each state feels climate change differently. And also there is a second layer to this problem, that is that the place where the environmental damage is generated is not necessarily the place in which such environmental damage is felt. So for these reasons, each state has different national priorities with regard to trade. While some could be super interested in the loss of pollinators, others may be interested in reducing carbon emissions. So national priorities are different. If national priorities are different, regulations and the prioritization of regulations is going to be different. So unification of local environmental regulations is impossible. Second reason for this is that geopolitics, that's the second reason. Developing states have voiced concerns about the impact of stringent environmental regulations on their economic development. So what they've said, they've claimed that developed states first are the major contributors to climate change. But second, they took advantage of flexible or lower environmental standards to achieve their industrialization levels. So why cannot developing countries use flexible environmental regulations to attain certain levels of industrialization? This is the, if I may, north-south divide. Developing economies believe that taking stringent measures on the environment could hamper their economic development. But the third reason, which I think is the crucial one, is that international environmental law does not promote harmonization. Why is this? Like, the international community, in fact, has strived to reach multilateral environmental treaties. In fact, the figure is that over 700 multilateral environmental agreements have been adopted since 1857. That's a lot. But these multilateral environmental treaties do not promote harmonization, nor have the tools to enhance the harmonization of local environmental regulations. Through these multilateral environmental treaties, states commit to certain environmental goals. But even when they commit to these environmental goals, the means and target the means and specific targets are different for each state. This is also reinforced by the ample leeway that these multilateral environmental treaties give to each state to define their own measures as an exercise of their sovereign powers. And third, this is further reinforced by the principle of common but differentiated responsibilities, enshrined among others in Principle 7 to the Rio Declaration and in the Paris Agreement. Under this principle, states should act for the protection of the environment on a differentiated basis, according to their needs, their historical and current contributions to environmental damage, as well as their tools, financial resources available to address the climate crisis. So even if environmental law recognizes common responsibilities, the specific obligations for each state are different. So this intends to bridge the divide between the North and South, but still this is at odds with harmonization. This principle is at the core of the Paris Agreement, and I will read Article 2.2 very briefly of the Paris Agreement. This agreement will be implemented to reflect equity and the principle of common but differentiated responsibilities and respective capabilities in the light of different national circumstances. So the Paris Agreement, for instance, imposes a binding obligation on each state to each determine a national contribution. And each contribution to climate change and a reduction of carbon emissions is different. So insofar as each party chooses its own contributions, it differentiates itself from the other. So that's why it's impossible to achieve harmonized environmental regulations. This is particularly relevant to the least developed countries. And if I may refer to Article 4.6 of the Paris Agreement, it reads as follows. Least developed countries and small island developing states may prepare and communicate strategies, plans, and actions to lower greenhouse emissions. And I want to underscore the term may. May indicates that LDCs and small island states are not mandated to reduce carbon emissions. So if some states are not mandated to reduce carbon emissions, why would they have the same regulations as, for instance, the European Union, United States? So, and this is also reinforced by the fact that environmental law not only contains this common but differentiated responsibilities principle, but also has developed in a piecemeal, fragmented manner. States have approached environmental crisis as a matter of particular issues. So carbon reduction, the protection of biological diversity, rising sea levels, each of them in a fragmented piecemeal manner. So this has created a regime that within the regime, you can find lots of inconsistency and contradiction among the obligations of states. So this further reinforces the fact that it's impossible to attain unified local environmental regulations. So in short, what's the main challenge? That while international trade requires harmonization of local regulations, environmental law at its core is at odds with such harmonization. So the multi-million-dollar question is whether it is possible to achieve a fair and free trade in the midst of differentiated local environmental regulations. That's the multi-million-dollar question. So how to achieve a fair and free international trade if environmental regulations are different among states? Neither the WTO nor preferential trade agreements give us a solution to this problem, the need for fair trade and different local environmental regulations. The current trade regime does not answer to this question, but rather accommodate to the current environmental piecemeal fragmented environmental law regime. So the environmental law regime does not push for harmonization, but promotes differentiated local environmental regulations. This is by no means random. This makes perfect environmental sense. Not all states have contributed equally to environmental degradation. And also, not all states have the same tools, financial capacities to address the climate crisis. But what does the current trade regime? What the current trade regime does? It accommodates to this reality of the international environmental law regime. Why? Because it contains exceptions as a way to derogate from trade responsibilities and enact unilateral, if I may, environmental regulations. Exceptions we have all discussed during this amazing panels, Article 20 exceptions, and with no surprise, Article 21 exceptions, because climate change, of course, it's seen as the primary threat to national security of states. So Article 20 and Article 21 allows states to enact differentiated environmental regulations. So we can say that the WTO promotes harmonization in the SPS, the TBT agreements mainly, and the TRIPS agreement in a way. But the reality is that we do not have an ISO nor a Codex standard setting institution or an equivalent for environmental matters. And if we do not have a renowned international standard setting institution for these matters, it's practically impossible to reach consensus about trade environmental matters. So if we do not have this standard setting institution for environmental matters, this is left for tit for tat, bilateral and regional negotiations between states. So using these flexibilities, Article 20, Article 21, states have adopted purely domestic environmental protection regulations. But these do not appropriately balance the interest in question, fair trade and environmental protection. Picture government enacting stringent environmental measures. These measures would likely be costly for their domestic industries. Very, very costly. What would happen if domestic industries crashed because they cannot compete with imported dirty products? Is that fair trade? I do not believe so. So should we all refrain from regulating or seeking environmental protection to protect the competitive advantages of our industries? That really does not achieve the goal of protecting the environment. So it's clear that using domestic environmental measures is not enough. It's not enough from a trade perspective, and it's not enough from an environmental protection perspective. So my take is that WTO members will accompany these domestic environmental measures with unilateral trade restrictions. Why? Using these unilateral trade restrictions as a way to balance fair trade the requirement of fair trade with the protection of the environment. These types of unilateral trade measures are driven by the desire to level the playing field for domestic industries operating under stringent regulatory regulations vis-a-vis those operating under flexible or lax frameworks. One of the most discussed examples of this type of unilateral trade measures is the already debated Carbon Border Adjustment Mechanism, CBAM, enacted as part of the European Green Deal. The EU adopted stringent domestic environmental measures, but accompanied these stringent domestic measures with this border adjustment mechanism as a way to level the playing field between EU and non-EU trading partners. The US Congress has also proposed the introduction of border adjustment mechanisms, for instance, in the Fair, Affordable, Innovative, and Resilient Transition and Competition Act, the Fair Transition and Competition Act. Unilateral trade advantages have both advantages and downfalls. I will refer briefly to the advantages. Unilateral trade measures can help to avoid the so-called carbon leakage, the regulatory arbitrage that we already discussed. These measures aim to equalize the competitive conditions made unequal by differing levels of climate reduction efforts in different jurisdictions. These unilateral environmental measures can also protect, if I may, the sovereignty of states wishing to adopt differentiated environmental measures, and also may promote sustainable practices worldwide, because suppliers located elsewhere will have to accommodate their practices to these domestic stringent regulatory measures. But now moving to the downfalls, which are the most important. Unilateral measures really do not solve the problem at hand. First, they may deepen the crisis of the multilateral system. And second, they do not result in clear environmental outcomes. As for the trade perspective, these unilateral trade measures may provoke retaliatory actions from affected states, worsening the current trade war. Second, in addition to retaliatory actions, unilateral environmental trade measures could also be regarded by trade partners as protectionist measures and covered veiled protectionist measures. And I will only refer to the EU, Indonesia, Malaysia, European Union dispute, because that's the case. These palm oil measures have been seen as protectionist by EU's trading partners. And as for environmental outcomes, these measures may increase, in fact, the trade of dirty, non-environmental friendly products between countries having lax environmental frameworks. And also, these unilateral trade measures can create the phenomena of dual production. What's this? That firms create one clean production to be exported to the EU, but maintain a dirty production line to export to countries having lax environmental frameworks. So I will just like to reiterate the importance of not appealing to unilateral trade measures as regarded in Principle 12 of the Rio Declaration, which states that unilateral actions to deal with environmental challenges outside the jurisdiction of the importing country should be avoided. And this was in 1992 in the Rio Declaration. So for me, and I know that my time is lapsing, but I just want to, I'll take one extra minute, if I may.
Sure.
The most important downfall of unilateral trade measures as a way to balance fair trade and environmental protection is that it impacts global governance through a phenomena called eco-imperialism. What's eco-imperialism? When confronted to a stalemate in negotiations on environmental matters, the global north has decided to adopt unilateral trade measures. And because of the vast market power of the global north economies, the global south has to adopt. There is no other way. One excellent example of this eco-imperialism, also related to the European Green Deal, is the EU's farm to fork strategy. The farm to fork strategy provides for the gradual reduction of chemical pesticides and intends to migrate the agricultural sector to organic agriculture. So the EU has enacted domestic restrictions on chemical pesticides and has accompanied these domestic restrictions with import restrictions to agricultural goods produced using chemical pesticides. This European Union regulation will de facto cut Latin America out of the market. Why is that? Because of our location in the tropics and the severity of the pests and plagues here in the tropics, we're not going to be able to migrate to organic agriculture, nor to reduce our dependency on chemical pesticides. So Latin America will be de facto cut out of European markets, and the interests of Latin America were not considered when adopting these restrictions, European green restrictions. So that's the real problem with unilateral trade measures. They're being used as global governance tools without due regard of the interests of the global South. So that's why, in essence, Principle 12 to the Rio Declaration vowed for consensual solutions to environmental crisis, not to unilateral ones. So even with this year's downfalls, unilateral measures are not prohibited by WTO law, neither by the and are not prohibited by environmental law framework. So just to wrap up, taking on domestic action alone to protect the environment does not balance environment protection and fair trade. Multilateral rules do not provide a clear solution. So at the current times, states are and will start flocking more and more to unilateral trade measures as a way to balance environment and fair trade. But unilateral trade measures deepen the crisis of the multilateral system, worsening the current trade war, and also do not yield clear environmental outcomes. So that's the current state of affairs. But not to be super pessimistic, what's my take and what's my proposal? I believe that we should shift the focus. The crisis of the multilateral trade system is not about trade. The crisis of the multilateral trade system merely reflects that we have not agreed upon how to protect core fundamental social values, such as the protection of the environment. So, to save the multilateral trade system, what we need is to shift the attention away from trade and start reaching agreements on fundamental matters, such as environment protection, and as a natural, effortless outcome, we'll have a reinvigorated trade regime. But this will only be achieved if we really shift the attention away from trade. Trade is not the solution to a current crisis. And this is a final call to invigorate or reinvigorate the legitimacy of the WTO as a forum to discuss non-trade matters. And maybe we need further justification. The current climate crisis will not only be devastating for the humankind, but will also have profound implications for international trade, as climate change induced disruptions can be dire to supply chains, transportations, infrastructure, and overall productivity. Thank you for bearing with me exceeding my time.
No problem at all, Sarah. Thank you very much for your presentation. You have touched upon a very interesting and focused issue now in the WTO, especially the principle of cooperation, the regulatory arbitrage, unilateral imposed measures, harmonization issues that are not possible in practice because national priorities, differences in the ways that we produce, that they conceive the way of production, narratives of protection of the environment, particular objectives to protect that are different among members. Yesterday, our colleague from the UK was referring to the objective to protect animals, that is more important for UK consumers than labor, for instance. Those are considerations that we should take and we should at least examine in the WTO and other multilateral scenario. Very relevant. The principle of CBDR-RC is also a core principle in the discussion. I don't know if you know that in our free trade agreements, we are trying to include those type of principles, cooperation, CBDR. We have it with the European Union, we have it with the UK. We are trying to also present it in other agreements. So with this, I will pass the floor to Juan. He will address the challenges ahead with these issues that we have been discussing in terms of the global political economy and environmental justice. Juan, you have the floor. Thank you very much.
Thank you so much. And really great to be sharing, to have the opportunity to discuss with you on this topic. I teach a course on international economic law at the law school. It's an obligatory course, compulsory course. The course, however, has in the last 5 years been transforming itself from a focus on WTO and investment to what I call now law and global political economy. Okay, because I think part of the problem, and I totally agree with this need for a shift of focus, but we should start here. We should start at the Society for International Economic Law, because when I look at the program, I just see trade and investment and a bit of war here and a bit of food security there. You know, if you look at all the posters downstairs, you know, there's only one that addresses social inequality issues. The rest, you know, and so this compartmentalization, this siloing, this considering economic stuff as different from other stuff, the idea that, you know, yes, we have to deal with trade and question, you know, trade and human rights, trade and labor, trade and environment is as old as the WTO, which by the way is not very old. It's only 28 years or 27 years, depending on how you count. And so we should get rid of our ideological bias of only seeing this particular institution and only thinking of international economic law as how can we bring markets together. Okay, because ultimately, you know, when you speak with people who do environmental economics, for example, they can tell you this is how much it's going to cost. You know, the climate change and all of these things, there's a price to that. And so how can we integrate those type of epistemologies, those type of questions, those type of sensibilities into the perspective on international economic law? I studied at the University of Leiden in the 1990s. So I was a student when they established the Marrakesh Agreement, even when the Rio conference took place, etc. And you know, so I think it's good to ask ourselves. One of my favorite verbs in Spanish is ubicarse. Where are you? Look at where you are. And ubicarse is a social, political, cultural verb. Okay, ubicarse is like know how people see you. That is ubicarse. So where are we right now? Where were we in the 1990s? Washington Consensus. The solution to every problem is markets. You have a problem, privatize, deregulate, open borders, free movement of capital in particular. Okay, that's where we were. Justice, markets will take care of it. You know, we'll have economic growth, we have happy consumers, we'll have trickle down, et cetera, et cetera. We'll have competition. And so, especially in the global South countries, when many countries, including Colombia, embraced neoliberal globalization with gusto, as they say in English, because we had faith in our ability to compete. Okay, imperialism ended in the 1960s. Neocolonialism, oh, you must be a mamerto, you must be a communist, whatever. History will take care of you. You know, as Margaret Thatcher said, Marks and Spencer, this big UK shopping store, defeated Marx and Engels. Okay, so, and where are we now? Where are we now is I hear people who are by no means mamertos or leftists speaking about imperialism or neocolonialism. Okay, where are we now? The markets will solve everything. If only it was so simple, because it turns out that markets need institutions. It turns out that markets are something that require a lot of regulation. Okay, so they tried, and CBAM is another example of that. They tried with carbon markets, emission markets, etc., and it has been a disaster. Okay, because we actually need to know what we want, and we need a common understanding of what we want, and we need, just like for standards and environmental protection, we need unified rules. Okay, markets need states. Markets need government, not just governance. Government need political communities. Okay, so where else are we now? Trade is a side issue. Investment is more important, but even at the national level, the most important institutions right now are financial markets, are financial agents. Okay, you have the 2008 crisis in the United States. Who do we help? The homeowners, Main Street, or the banks, Wall Street? And the choice was Wall Street, because somehow we cannot conceive of a stable economy or stable anything without financial stability. Okay, and so here's a couple of things that I would propose, and this follows out of my of the way I've been sort of like molding my course to be more in focus with the way I understand my pedagogical responsibility is students. It's very unlikely that they will actually be able to work in international economic institutions like the WTO or with trade issues. Most of them don't want to anyway. I always ask how many of you would have chosen this course if it wasn't compulsory, and you can hear the crickets. And so the subtitle of my course is "How does the world work? Okay, how does it function?" And the answer is global political economy. Let's focus on an integrated perspective on institutions, law, history, ideology, and what people doing economics do. So one analytical framework that is very useful is global systems theory. Global systems theory, for those of you who know, it's also old-fashioned, 1970s theory, Marxist, and so therefore useless in the 1990s, thinking in terms of core, periphery, thinking in terms of the world, not just now, but always, as already a world system, as already a unified economy. Okay, there was no industrialization without cotton being transported from Asia and the Caribbean and the United States to the United Kingdom. There was no industrialization without slavery in the United States and the Caribbean. Okay, so it has always been a global economy. Okay, so if we understand that, and then we see the patchwork of states being sovereign and unilateral and all that stuff, then what we see is a mess. It's a mess, but not one that significantly alters the fact that we are a world system, that financial markets are centralized in just a handful of places, that the way we understand markets tells us a lot about the way we understand the world. And so one of the things that I do in my course is I compare the project of European integration, which is about establishing a common market, and which basically required institutions and made it unavoidable to have political integration. I compare that with the project of the United States, which was never a project of integration. And it has the same thing you described operates in the United States. Decentralized regulatory authority, a very limited federal authority. You have the Commerce Clause, which has been inflated to sort of like fulfill the task that institutions did in the European context. And of course, the Commerce Clause is now being attacked by the Republican judges. It's being diminished because they considered it was too much centralization. And so what you get is that you see not a leveling of the playing field for market players, but what you see is a competition amongst market players. But what you see is a competition amongst regulators. Okay, so you have, the question of which state has the biggest jurisdictional footprint becomes important. And so you see California basically setting the standards for the car industry, even though the car industry is not in California. Okay, and so, and the same for environmental standards, etc. Why? Because it's just the biggest markets. The big market players want to basically follow the biggest market regulator. Okay, and so I think if we go back to that analysis, I think the WTO was established very much in a period in which international organizations was the thing, in which regulatory verticalization was the thing, okay? In which basically, especially in the European Union, and the European Union was very important in terms of how to set up the WTO, we saw the European Union, the common market with a couple of institutions, as the future of the world. This is our objective, a global common market with global institutions that only do technical stuff. That was the fantasy in the 1990s, okay? But if we shift to the United States, we see that actually, their idea of a common market is secondary. It's not about harmonization. It's not about centralization of authority. It's about other stuff. And they have freedom of movement of people, by the way, which is also incredibly important in the US economy. And so global political economy can help us sort of shift our focus away from not just these particular institutions with their imaginary, with their ideological biases with regards to what trade is and what markets are about. Make us more attentive to historical and ideological dimensions, become a bit less understanding of this epistemological and institutional fragmentation, because I say WTO, throw it out the window, or it should reform somehow, okay? Because it's actually I mean, it can do stuff, but for fisheries, for example, but it's actually pathetic in comparison to the challenges ahead. Okay, and so yes, common fundamental social values, absolutely. But then we need to understand that what stands in the way of us agreeing on these fundamental social values are epistemological and institutional siloing that we have. Finally, just a shout out, because I already mentioned the most important institution right now in the global economy are the financial markets. And so, and you see that the ideological discussion is now around that. It's around ESG, okay, or woke capitalism. It's already being polarized. It's already being identified as the new Mamerto communist plot, okay, which is hilarious because it's like the beating heart of capitalism. But and it has been a good idea, but it has also been a farce. There's been like massive greenwashing going on. ESG investors basically financed the Saudi oil company recently. So what are we talking about? ESG. But I think that's the way to go. You have to, as Lenin said, the commanding heights, you have to control the commanding heights of the economy. In his age, heavy industry, steel. In our age, financial markets. And so where are the financial markets in the Society of International Economic Law? And why aren't they there? Why don't we, regulate that? Because, yes, imperialism, that is totally imperialism, plus add the tax havens to that. Okay. So yeah, I just want to leave it there because I've spoken long enough and I want to open up the conversation with you guys as well. So yeah, WTO, bye-bye. In Society of International Economic Law, more political economy, please. More interdisciplinary stuff, please. And ask seriously the question of, what is justice? That shouldn't be kind of like, oh, that's for philosophers and theologians. No, it should be a question for everybody.
Thank you very much, Juan. And this has been a very interesting presentation and very thoughtful, very provocative, right? So I totally agree with you with the fact that this Society of International Economic Law did not take or did not consider the core important issues. Development. I didn't see one panel, maybe one panel on development, one panel on developing countries. This I think is the only one that grasps a little bit this issue of, and yeah, this it's the trend of international arena. The financial markets are there, the colonialism there, the big countries are there. And how about the developing world? We are just in the periphery. Do we need to act? Do we need to do something? And we have to change the paradigm. And I totally agree with you both that there is a need to change the paradigm, and there is a need to ubicarnos, like you said. We need to place ourselves somehow. I now will change from the role of moderator to the role of the panelist for a bit. So I'm able to explain what Colombia, as a developing country, biodiverse country, with new ideas, this little minion idea to change the paradigm is doing in the WTO. So I will take out my hat of moderator and I will give it to Sarah, so she will moderate my presentation. And of course, afterwards, we will open for questions.
Thank you, Gustavo, for the moderator role. Briefly, just to chip in the previous discussion, I believe there is we have a responsibility to overcome the specialization of lawyers. Why? Because if you know trade, you cannot know about investment. But if you're an expert in trade and investment, you cannot be an expert on financial markets, and you cannot know environment matters. So I invite you to read the really interesting book about how generalists triumph in a specialized world, because we are, I believe, as a community of lawyers, scared of delving into new areas of the knowledge. And if we keep over specializing in only trade, and the GATT and the SPS and interpretation and Vienna Convention, we are closing our eyes to the reality behind the rules, which are economic realities, environmental realities, physical barriers to attain environmental protection. So just a brief call to keep not being afraid of being generalists and knowing bits and pieces of everything. Why not? Why is it so important just to be a trade expert? That was a brief call. But now returning to our call has been to especially consider the interests of maybe global South economies, and to understand that the current norms are just a reflection of disagreements on core fundamental values. But then, as Juan complemented, these disagreements on core fundamental values are not easy to solve, because we have lots of paradigm and geopolitical problems that impede us to attain these agreements. So with that in mind, I would like to ask Gustavo about this proposal of the government of Colombia in the WTO, having due regard of the interest of the global South as Colombia. And I would like to ask you, how does Colombia's proposal aim to address the design and implementation of trade-related environmental measures within the framework of existing international law and principles? And what specific principles or guidelines from public international law does Colombia seek to incorporate to its proposal?
Thank you, Sarah. And I'm glad that you had that question. We are here talking about law, international economic law, and we disregard other type of international law that is there, that is qualified as principle, is qualified as binding, is qualified as something, but we don't take advantage of it. And that's the proposal from Colombia. So discussions and debates now at the WTO are on these hybrid measures on trade on one hand, with these environmental objectives, as I described in the introduction, and how the interaction between those words should take into consideration the calls from developing countries members. And that's something very innovative, at least in the way that we want to present it. We don't want to talk about trade, and we want to talk about measures that help us to protect our environment. And some of these measures are trade measures. So the focus of the proposal is to talk about principles and guidelines that already exist in the international area. We need to talk about those principles in the two worlds. I've seen that the environmental international world, even if we are in Geneva, and in the international trade world, we talk two different languages. We don't know what we are talking about. And that's something that we have to change. We don't intend that international trade law and environmental law get married, but at least we want these disciplines to have some flings time to time, so they get to know each other, and the way both worlds can communicate in similar languages. it is important to know that those principles are the result of discussions in the WTO, especially with South countries, global South countries, the Africa and Asia, and they're not exhaustive. They can be more. These are just 4 that I will present today, but they can be 10 or 12 principles that are coming from international environmental agreements, but also international public law. The legal status is not, it may vary depending on if we are talking about the Biodiversity Convention or the climate, the Paris Convention. So it doesn't matter if there are principles or there are customary law. The important thing here is that they should apply to these average measures that we want to consider. And there is not a particular hierarchy, of course, because they should apply holistically. And that's the discussion. That's what we want to achieve. And something very important, we don't want to present these principles as background of negotiation of new treaties, because that's some kind risky. And now with the fisheries negotiations on the table, that could work also as a trigger for extreme waiver. And we don't want that. We want rules. And we want rules that also help us to protect those values, the core values that you were talking about, right? So the environment is a common concern. The climate change is a common concern. It has been presented as a common concern in many treaties and international agreements. And trade and trade policy have the role of this transition from no protection to protection. Also, the UNFCCC, the Convention on Biodiversity and other conventions have provided for this common concern. So now let's go to the principles. I have 4 principles to present to you today, and I think we have at least a map of why those principles are so important. You were talking about cooperation, the importance of cooperation, so the duty to cooperate in a spirit of global partnership to address environmental degradation. That's law. That is provided in the principle 7 of the Rio Declaration. Also in the WTO, we have discussed this in the Trade and Environment Committee. And the principle of cooperation, there are 3 particular elements that we have to bear in mind. The principle of cooperation, first, is not only about financial assistance, and is what some developed countries want to present to the developing countries. So they say, oh, we have the Green Deal, oh, we have these measures, we will help you with $100,000 or 100,000 euros, and you have to comply. That's not cooperation as a principle of international law. The principle of cooperation refers, to developed countries, providing cooperation to developing countries. That's provided in many agreements, as the UNFCCC Article 3.5. But the cooperation also includes the strengthening capabilities for protecting the environments. So capacity building, including, and I'm referring expressly to the law, including collaborative approaches to research and development of technology and enhance its transfer. So it means financial assistance, yes, but it means technology transfer, and it means capacity building. So those 3 elements, including the interaction between developed and developing countries, are necessary tools that we need to consider when we are talking about those trade-related environmental measures. The second principle that you referred to it, common but differentiated responsibilities and respective capabilities. This is a principle a bit more related with climate change, but never mind, we want also to reflect the principle in on other areas of international environmental law, also soil degradation, water degradation. We are negotiating that right now, and we want the CBDR to be included there. Also, as part of the bilateral trade agreements, we have the two trade agreements that embed the obligation to respect the principle of common battle principle. How we ensure that, how we apply that, well, that's the question. But this principle has two elements. First, states have common responsibilities to address the global environment degradation, yeah. And second, those responsibilities are different, and are different because they have two components. Of course, the historical, current, and future contribution to the environmental degradation. Yes, we are not all guilty of pollution. We are not all guilty of greenhouse emissions. And second, the capacity component that reflects socioeconomic situations, technological and financial capacity to contribute to the protection of the environment. Those elements have to be taken into consideration when the design and implementation of trade-related environmental measures. The third principle that I want to talk about, and we have presented also in the WTO, is the principle of prevention. So is the obligation to adopt measures to prevent significant harm to the environment. These principles can be involved in the application by justifying trade-related environmental measures. It also has two elements. So states have the sovereign right to exploit the natural resources. First one, their own environmental and development goals, yes. But those activities should not cause damage to the environment of other states or areas beyond the territorial limits. Also, a very important principle to take into consideration when we are applying these measures. Okay, the fourth, I think you are also experts on the principle of non-discrimination, but very important measures differentiating between products that may be similar, like products that we call in the trade world, based on environmental considerations, can be justified by Article 20 of the GATT. However, when we measure that justification, literal A, literal G, so measures should be necessary to protect human, animal, and plant life and health, or G, measures should be relevant to the protection of exhaustible natural resources. What are exhaustible natural resources? Air, water, biodiversity, and soil, subject to the requirements that they are not applied in a manner that constitute means of arbitrary or unjustifiable discrimination between countries where the same conditions prevail. And between countries when the same conditions prevail means that the conditions that include in other members, in other countries, methods of production that developing countries have should be taken into consideration in the design of those measures. Because if not, the measure will not fulfill the requirements of the chapeau of the Article 20. So beyond the principles and existing rules, I want to open questions because we don't have time. So I think it is important that our reflections on the topic discussed here aim to play a role in providing a common reference point, a change of paradigm, cooperation approach. And I think these scenarios is where we need to start, at least to bring the voices to institutions that are almost inexistent, like the WTO, or are the Titanic, that are almost sinking, but still I have my salary from there, so I have to defend it. And yeah, other scenarios like, of course, the WTO, but also the UNFCCC working groups, that it's important that we at least talk similar language, it's not the same. So thank you very much for your attention. I'm happy to answer any question. Just feel free to address to all of us the questions. I think these have been very interesting. At least I have learned from both of you. You have been amazing panelists. Thank you very much.
Thank you. Thank you.
Okay, in relation with the balance between efficiency, free markets, and social justice, the environmental protection, the problem, I think the problem is where you put the limits to identify what is a vulnerable country, a developing country. Because what I say that because you have to in these countries you have to attend many standards of regulation, in financial regulation, trade regulation, international law, but you have the problem that you don't have the you are late to the benefits of the development. Yes, the country have to have the benefits of the development, but you don't have access. Historically, you don't have access to these benefits. You have to industrialize countries. Okay, and how obtain the consensus that you say? The consensus in this problem, in this balance. How do you have the consensus if you don't have the consensus at the internal political peace? Okay, I have this is a problem, the real problem.
Okay, but do we have more questions or online? No?
Yeah.
Yes.
I just want to ask you, feel that everything that we're experiencing right now is a fail of our Western vision of capitalism and trusting everything to the markets, because we have pressing issues right now. We talk about free trade more than fair trade that you were talking about. I think what we were aiming to, or the people before us were aiming to, was free trade. And now I don't know if we are going to be able to see how this is going to happen, because we're experiencing such extreme changes that humanity is at risk. So yeah, awesome, free trade between whom, right? So it is a failure of capitalism as we know it. That's the question.
Any more questions? Do you want to?
Maybe I can start with the,
Yep,
the consensus
sure.
question. I don't want to be overly pessimistic, but I believe that consensus is impossible. It's impossible. So what can we do? We know that we have a trade system that does not like unilateralism. We have an environmental system that requires unilateral measures and differentiated unilateral measures to protect the environment. And we do not have a solution. So what can we do? We can sit and be grumpy about it and have lots of conferences about the topic, but we can also work with what we have. What do we have? An impossibility of global universal consensus. But we can achieve well-adjusted unilateral measures. I do not want to demonize unilateral measures. And we can achieve important regional bilateral agreements. So what can we do? Be aware of the downsides of unilateral measures, such as not accounting for the interests of the global south, unilateral measures that as a side effect increase the trade of dirty products between states not having high environmental standards. So we have to be aware of all the downsides of acting unilaterally to protect the environment, and then designing unilateral, bilateral, regional measures that account for those downfalls and try to minimize them. So for the European Union and Green Deal matters. I know we've referred a lot to the European Union, but the Green Deal, it's being a huge thing for Latin American countries because the EU is a really important export market. We have 27 economies that buy our foodstuffs, mainly agricultural products. So that's a big issue for us. So what can the EU do to account for the downfalls of unilateral measures, such as the CBAM, the import restrictions on products with chemical pesticides, and so forth? The deforestation, we did not talk about the deforestation due diligence guidelines that are also very scary for us. What can the EU do? They can start calling us to voice our concerns and involving our industries, not at the end of the process of decision making, which is the W mandated participation method. That once you have the measure, the draft measure, you have to notify to the WHO, and then you can discuss. In that moment, discussion is futile. The regulation is already completed. So the EU could, for instance, call us to participate very early in the decision-making process to make well-adjusted measures. I am not saying that the EU has not discussed these measures with the Global South. I know that we've discussed a lot with the European Union about how to comply. So for instance, we have cocoa, sorry. The big issue with cocoa is the cadmium levels of cocoa. So the main issue with the European Union has been, we need money and capacity building to have cocoa-free, cadmium-free cocoa and export our cocoa to the EU. That's not the question, how to get more money or how to get more capacity building. The question is how to have a regulation on cadmium that really accounts for the geographical locations of the Global South. So the discussion is not, let's make a unilateral regulation and then give out money and capacity building, but how can we reach bilateral regional consensus before reaching this draft regulation? So I think that's a way to work with what we have, understanding the negative downfalls of unilateral or bilateral regional action, this compartmentalized action, and then trying to mitigate these risks. And I think that it's possible to have well-adjusted unilateral measures for the protection of the environment. That's like the pessimistic, not pessimistic approach.
Excellent. Well, I will pass the floor to you, Juan.
So as the Italian Marxist Gramsci used to say, you know, pessimism of the intellect, optimism of the will. Okay, so if we look at the world, we should do it with pessimism because it's a mess. It's a mess. It's destructive. It's unfair. It's everything. But then, you know, we act with what we have. But one thing that I would add, I mean, the general question that you raise is the question of world systems theory, which is we have already a very integrated economic system, sure, with all of these different patches and barriers and geopolitics, et cetera, but it's actually already quite integrated, and you have core countries and periphery countries and semi-periphery, et cetera. Although, as I like to explain to my students, it's a relational structure. So just like the world has a core and a periphery, so does Bogota. Also has a core and a periphery. Okay, the core is basically concentration of capital, human capital, technology, and that moves around, also within countries and among countries, et cetera. And so that is the problem. So I think what we need is more analysis, more reflection, instead of looking for formulas, because that's what happened in the 1990s. You know, the globalization of markets became the formula. You know, it became there's this English expression, you know, for a man with a hammer, every problem is a nail. Okay, so deregulate, you know, privatize, open up markets, anything. Protecting the environment, markets, just throw it onto the markets, sell it, commodify it, etc., etc. So, but what we need is imagination, and we are in a good moment because we don't have an overarching consensus right now. And so intellectually, we have all the space that we have, that we can, that we want, that we need in order to imagine new forms of governance, new forms of understanding the way the world works. And then, so because one of the key questions that I always come back to in my course is, okay, so, now that we have sort of a bit of a map of the world, so what does a lower middle income country like Colombia do? Okay, how can we be savvy? How can we be smart to use the little leverage that we have? Because if we ubicarnos, if we locate ourselves, we are dependent. Like the most important news after the election of Petro was, what do global financial markets say about all this? What is the price of the dollar, the price of the peso, et cetera, et cetera? We are already being governed by other forces. Okay, we need to know that. That is ubicarse. Okay, and so once we really know that and understand that, and also know that it's not just a question of lowering our standards so that we get more investments, because the investment always flows to expensive countries. It doesn't flow to poor countries. If it was that simple, Somalia would have the biggest investment, but not. It's Sweden, Japan, South Korea, the United States, they get the biggest investment. Okay, so it's not about, oh my God, we can't raise the minimum wage because then the investment will never come. No, that doesn't work like that. And so we need to be a bit more sophisticated in our understanding and in our analysis. And as for your question, that's another question of where are we now historically? Historically, where is capitalism? I do a lot of work on due diligence stuff. There's a parallel panel that I would have been if it hadn't been for this opportunity. But I see it. I see it as a symptom of a paradigm shift that is already happening. So we like to say, we need a paradigm shift and this is it. Sometimes we need to see the paradigm shifts already happening. And due diligence is an area. And what is the paradigm shift that I see? I already mentioned stakeholderism or stakeholder capitalism, and which involves not international law, it involves corporate law, it involves contract law, it involves administrative law, it involves torts, etc. And what is stakeholder capitalism? I mean, like anything, like democracy, like whatever, it can be used badly or used rightly, but if you know that, then you can push it the way you want. Stakeholder capitalism, in my opinion, involves two things. One is dealing with negative externalities. If there's one economic term that you need to know, it's about negative externalities. Okay, it's the costs that you put onto third parties, not the consumer, not the producer, onto third parties, negative externalities. So it deals with the question of negative externalities and tries to somehow internalize that into the decision-making process of capitalists. And second, and that's the environmental justice dimension, it seeks to incorporate stakeholders. I know lawyers have nightmares about stakeholders because what the hell is that? I need right holders, I know. Okay, but stakeholders is too loose, too general. Okay, that's one of the things that we need to get over. Stakeholders are people who have a stake, who have an interest, who somehow can claim to be affected. Okay, and they can be incorporated, included in the decision-making process. Okay, so that would be stakeholder capitalism. And as far as I can see, it's our best bet. Outside of revolution, which I don't see as a viable or appealing alternative. Yeah.
Okay. I think the time is over, but thanks to you. Thanks for your questions.
Someone here Zoom has raised their hand, but I don't know if they do have any questions.
It's up to you. Yeah, please.
I don't know if you want to ask something right now because they had raised their hand, but I don't know. You can open your microphone.
Hello. Who is that?
Yes.
Pierre? Pierre Sauvet?
Still there? Can you see because there was 7, now it's 6.
Can you hear me?
Yes.
We can hear you. Yes.
Pierre. Hello, Pierre.
Yes. Hello. I can. Can you hear me? Because I don't know if you can hear me.
We hear you.
Excellent. Well, thank you. I've been following up this discussion, and well, first of all, I would like to introduce myself. I am Pierre Horna. I have worked. I'm still working actually in the UN for the last 20 years. I have been in the same university as Juan Manuel, Leiden University, back in the day, in 2002, actually, not earlier, Juan Manuel. But I joined the UN in 2003, so it's been 20 years working at the United Nations in Geneva. But now I have moved, after 19 years of working in Geneva, I've just moved to Bangkok to work in Asia Pacific on climate finance, by the way. So yesterday I was also in charge of a conference, part of this conference, panel 7 on IP and competition in terms of COVID-19, because I've been working with my colleagues at the University of Lima in Peru. But I just wanted to have, well, first of all, congratulations for the great reflections about the age of challenge of multilateralism. I've been working on trade and competition for 19 years as part of the system, as part of the Secretariat of the United Nations. I've traveled to more than 100 countries around the world working with competition authorities. And last 2020, before the pandemic started, I published a book on cross-border cartels, precisely focusing on countries that nobody talks about, basically, small developing countries. We call it younger and smaller agencies in the world, based on my work, working with them for 15 years. But recently, I decided to do a move, to go to climate justice, to go to climate finance, to work on different matters. And I had been given this opportunity in the UN Secretariat to work at the Commission for Asia Pacific. And I must say that I've changed a bit what I've been working on. I mean, my approach, and it's more or less in line to what it has been discussed, but in a different way, because of course, I mean, being part of the system, being part of the United Nations, it has been a very rewarding experience for one, but also, you know exactly what's going on when it comes to the geopolitical dynamics of the member states, particularly those that I'm working more closely, which are least and developed countries. So in your discussions, of course, you made a very realistic view on what's going on. I agree with Juan Manuel about Ubicaína, but my point is this sort of subject matter that has been out there, and I'm telling you because I've seen it currently in the last 7 months that I'm working here in Bangkok, how to work on matters that he has been touched upon for so many years. For instance, sustainable finance. Sustainable finance, it's been there since the 90s. LDCs are currently catching up. In which way, you know, what type of taxonomies we are talking about here? What type of green bonds? The other day I was talking with a member of the Central Bank of Cambodia, that very nice lady who told me, look, we issued a green bond the other day, and the green bond was actually sold in Germany, but the proceedings are actually back in Phnom Penh. So how do we organize that sort of phenomenon, where the specific type of sustainable finance instruments are basically in developed, as you rightly say, in developed capital markets. But I've looked at it from the other perspective as well. And the other perspective is a little bit more positive than you actually have seen it, because having talked to these sort of policymakers in the small little countries, I'm talking about the Republic of Kiribati, for instance, in the South Pacific Islands, and those islands are vulnerable to climate change. And you know how it works when it comes to these particular areas. Bangladesh, I don't know if you recall the latest COP27 in Sharm el-Sheikh. The only delegate who talked about climate justice was a delegate from Bangladesh, and he did it on the opening remark. Now, after that, how many people talked to him later on? How many people approached him directly? Now, the next COP28, which will be in Abu Dhabi, as you know, will be discussing areas that are already touched upon in Bonn, in the climate secretariat in Bonn, the UNFCCC. And all these matters are actually, we call it, it goes in cyclical ways, And in my case, for instance, having worked for so many years on antitrust issues, having worked so many years with consumer protection issues, having worked with so many years with financial markets, but from the different perspective with the markets, as you rightly say, I have a different view to what you have said, because I have considered that the work that member states have doing, at least in the region I'm working more closely now, the Asia Pacific, they don't really do copy and paste from the taxonomies that are in the EU, for instance, the green taxonomy or the Green Deal, as you rightly say, even coming from China, which are a lot of interests in Indonesia and Vietnam. And the last point I want to make is, I'm not sure whether you are aware of this, but since the G7, they have come up with what we call the Just Energy Transition Partnerships, JETPs. These JETPs are billions of dollars of help, but not only from developed countries, but from the developing countries themselves. These have been signed recently by only 3 countries, and I think Senegal is the 4th country in the world. We're talking about South Africa at the Glasgow event in COP26. We're talking about Indonesia and Vietnam. And those 3 countries are actually taking their time to implement what we call the JETPs. But the word just precisely talks about the dimension that you are referring to, the dimension of not only talking about markets, not only about specific interrelated dimensions, but also social justice, but also consumer protection, worker protection, labor laws, and many other areas. Now, Just Energy Transition Partnerships, as we call it in the jargon of financial people, JETPs, are actually going to pick up, whether we want it or not. Now, the question is why China is not there. China, as being the major partner in the Asia-Pacific region, is not there. It's only ruled by G7 countries. So the moment I talked to the Chinese delegate here in Bangkok, he said, please don't mention that, because we talked about energy transitions in general. And these type of things will work and on and on. So what my lesson learned in these times that I'm here in Bangkok is that climate finance, climate, that we all talk about the sustainable development goals and the achievement of that we are not going to be in track because of the pandemic and everything like that. But finance has been a democratic concept, to my knowledge, at least, because I've seen it with my own eyes, in the very small countries. They don't take it directly they have learned, even within Indonesia and South Africa, which are emerging nations, they take it with a lot of caution. The developed countries' instruments, they are not being imposed. And I can tell you for sure, because I'm talking with these policymakers on a daily basis. So that's what I want to do from my perspective, coming from different angle. And thank you for a great discussion. Thank you.
Thank you very much, Pierre, and those messages have been very, very interesting. I think the time is a bit over, but I think we should keep in touch, because your perspective it's very useful. And now I think there is an issue there also related to finance, which is the issue of transfer of technology. And if we are talking about environmental, like climate justice, how we will deplete these environmental trade sound technologies that are now trying to enhance this transition to a green economy. But let's talk about this later on. We have to close the panel because we
problem.
Break. Thank you very much, Pierre.
Congrats, and see you all. Bye-bye.
Bye-bye.
Gracias a todos por su asistencia. ¿Les parece que nos tomamos una foto? Es que les van a cocinar un café.